I'm very pleased to welcome Nick Singer onto the channel. Nick is a barrister from 42 Bedford Row, and one of Nick's key practice areas is employment law. Nick's going to talk to me about whistleblowing, and in particular, the public interest test. Nick, thank you for joining me.
Thanks, Matt. Pleasure to be on the channel. So what is whistleblowing? Well, the term we use as lawyers is protected disclosures, but as I say, it's more commonly known as whistleblowing. And when I was researching this talk, I looked into the origins of it, and as it may come as no surprise that the reason it's called whistleblowing is because someone blows a whistle, they're usually calling out bad behavior. So, for example, the police used to chase criminals for reasons that are unknown to them and used to call out their criminal behavior by blowing a whistle. The same when a football referee blows their whistle in a football match. And in the workplace, it's exactly the same. This is about employees or workers calling out bad behavior in the workplace. I've never heard of a case where someone has actually blown a whistle, but if anyone does know of a single case, please put it in the comments below. So where we start is the Employment Rights Act 1996, section 43B. That's the Employment Rights Act 1996, section 43B. Now, to get a claim like this off the ground, you need to persuade a tribunal of two things. The worker has to reasonably believe two things: that a disclosure of information tends to show something. So a disclosure of information tends to show that somebody is breaking the law or breaching health and safety or committing a criminal act. But the second part, and that's going to be the focus of what we're doing today, the worker has to reasonably believe that the disclosure is in the public interest. So for the first part, you might have somebody who takes a photograph of needles that are lying around on the floor of an NHS ward. So they would be disclosing information in that photo, which they reasonably believed showed that somebody was breaking health and safety, because of course it's not usually good practice for a doctor or anyone else to leave needles lying around on the floor of an NHS ward. So they'd reasonably believe that somebody was breaking the law, or say breaking health and safety, by leaving those needles there. But they also have to reasonably believe that they are making the disclosure in the public interest. Now, this was entered into the legislation by Parliament because Parliament wanted to look at the bigger picture. They didn't want this legislation to be used by workers to resolve private disputes, contractual disputes, wage disputes, things like that. It's about the bigger picture and calling out big behavior, big bad behavior. But hopefully, as you will see during the course of this talk, it's not always easy to draw the dividing line. So the main case in this area is a case called Chesterton Global Limited. That's Chesterton Global Limited. And it concerned a number of disclosures about the accounting practices of a private company. So there was an office, a big office based in Mayfair, and apparently the people there were misstating the accounts. And this was affecting not only the worker's salary package, but about 100 of his colleagues. So this would be a dispute about legal obligations, the worker in question reasonably believing that the information he was disclosing tended to show that someone was breaking a legal obligation. But the employer said, hang on a second, Parliament have just introduced into the legislation, it has to be in the public interest. This is exactly what they were trying to avoid. We don't want disputes about wage package and salary packages and all the rest of it. But the Court of Appeal disagreed with them. And in doing so, they came up with a test that a tribunal should look at when considering whether something, or at least considering whether a worker can reasonably believe something is in the public interest. They've come up with a number of tests. So the number of people that the disclosure served, the number of people involved, who was affected and how badly were they affected, who did wrong, and what did they do wrong? So there's a number of factors the tribunal would always have to look at in a case. And in this case, the Court of Appeal said, look, yes, this was an internal dispute, there were internal accounts, but these accounts fed into public accounts. And given this was a prominent business in the London property market, it was quite a substantial business, it could have a knock-on effect. So what the Court of Appeal said, yes, it could be about a workers' contract. And although the aim behind it was to avoid this sort of thing, in theory, even if it is what looks like a private dispute, if it has public elements or can have public knock-on effects, it can still be in the public interest. So perhaps, and this is what the lawyers were all saying at the time when this decision came out, perhaps the test is a little bit broader than we all anticipated, but that's where we are. So looking at some examples of how this might work in practice, there are two things a tribunal must consider. Firstly, does the worker genuinely believe the disclosure he or she is making is in the public interest? And if they genuinely believe it, does the tribunal think it was reasonable for them to believe it? So it's not for the tribunal to say, well, we think it's in the public interest, or we don't think it's in the public interest. It's an objective test, but analysing whether the worker's own belief was reasonable. So going through the Chesterton factors that we just looked at, numbers of people. So for example, using the NHS as an example, because it's often can be an NHS case and it's a useful example, look at a medical procedure. If somebody thinks something's going wrong with a medical procedure, health and safety or legal guidelines aren't being followed, that could affect 1,000 or 10,000 or 100,000 people across the country. So that, I think, is more likely for a tribunal to say belief in the public interest in that sense was reasonable. But then maybe it was just, a cleaner who wasn't following health and safety guidelines on a single ward. It's quite a limited impact on the number of people. It's sort of situation, maybe you could have a word in the cleaner's ear, just say to them, look, you need to follow the guidelines. It's quite small, quite isolated over a short period of time, not many people affected. And that, I think, would tend to be less likely to be found to be reasonable in the public interest. Second part of the test, what did they do wrong? And you need to be looking at whether there's something inherently public about the wrongdoing. So things like crime or sexual harassment is probably more likely to be viewed as being reasonably to believe it's in the public interest. So that could the wrongdoer, for example, do it to someone else inside or outside the workplace, commit a crime elsewhere? And is there a wider societal interest? So with sexual harassment and the Me Too movement, of course, it's become part of society where people are being encouraged to speak up about sexual harassment. It's an important part of trying to snuff it out of society and the workplace. So if someone's raising sexual harassment, that I think would more likely be viewed as something which was inherently more likely to be in the public interest. Where there are financial questions, as there were in the Chesterton case, you'd be asking yourself, or the tribunal would be asking itself, how big's the employer? Is it a big business where the mismanagement of funds could have catastrophic effects on the economy, as opposed to a much smaller business? So a company like Carillion, as we all know, was sort of absolutely massive and had lots of government contracts. Are they small errors, or is there a deliberate fraud? And I think the more egregious the behaviour, the worse it is, the more fraud-like it is, the more likely a tribunal will say it's reasonable to believe it's in the public interest. And of course, were there public funds involved? That would, I would imagine, be an important factor. And finally, who did wrong and who was affected? So it's always very important to put this sort of thing into context. So where did it arise? Where did all these things happen? Where did the disclosures happen? Was it a private institution? So you can imagine a health and safety problem in a sort of family-run tech business is, where there aren't any members of the public coming into the building, they don't have clients on site, really is a private problem between a few people working in a building. That, I would suggest, is less likely to be viewed as being in the public interest, or at least for the worker to reasonably believe it. But you could have a private institution that serves the public or has many members of the public attend. So a gym or a swimming pool that has a health and safety problem would be very different from the family-run tech business, because of course health and safety of a swimming pool or a gym is much more likely, almost certainly, going to affect the public. And of course, if it's a purely public body, something like the NHS, then it's more and more likely a tribunal is going to be looking at the worker and thinking, yeah, it's reasonable for them to believe this is in the public interest. But of course, as we've seen with the NHS examples I've given, it isn't always going to be the case. You take all of these factors into consideration. And finally, who is the person that is the subject of the problem? So you have to ask yourself, how much power does the person have? So if it's something being done wrong by a chief executive who has power over 100 people, that I would think would be viewed very differently by a tribunal than perhaps if it was a very particular issue in a small admin team of an administrator who's on the lowest pay grade, who has no power or control over anybody. Does the person work with vulnerable people? If somebody doesn't actually have the ability to look after themselves, there may well be a public interest in calling out that behaviour. So I hope I've been able to demonstrate that there are almost an infinite variety of circumstances. And of course, each case is different. Each case turns on its own facts. Each case turns on the tribunal that hears it and the evidence that comes out at tribunal. But as I say, I hope that's given you a flavour of the sort of things that a tribunal is going to think about, and whether you're an employee or an employer or a worker, the sort of questions you might ask yourselves if you're faced with a situation like this.
That's great, Nick. That was really informative. Thank you. I'm sure a lot of people will find the video really useful. And thank you so much for coming on the channel and sharing the information.
Thanks, Matt. Absolute pleasure to be on the channel.
Thank you, Nick. For more information, do browse this channel and visit my website. Remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And finally, please subscribe to my channel for updates.